provisions were dispensed with were repealed by way of an definition clause, not like unlike interpretation clause. Here kindly bear one factor in mind. 370 sub-article 3 has an inbuilt extinguishing provision. 370 sub-article 3 is a provision whereby 370 can be extinguished. That's the distinction. But I'm on a little wider argument made by the other side. Para 19, the submission, my Lord Justice, the submission advanced by Mr. Sorabji, the learned senior counsel appearing on behalf of the writ petitioner in writ petition number so-and-so are thus, Article 291, 362 and 366(2). Well, 366(2) is the definition clause defining princes then of the Constitution, were integral part of the constitutional scheme and form the important basic structure, since the underlying purpose of these articles was to facilitate submission of new order and ensure organic unity of India. These articles guaranteed pledges to the rulers based on elementary principles of justice, and in order to preserve the sanctity of solemn agreements, it was only by the incorporation of these articles that the unity of India was achieved, by getting all the rulers within the fold of the Constitution, and that the deletion of these articles has damaged and demolished the very basic structure of the Constitution. The covenants entered into were in the nature of contracts which had been guaranteed constitutionally and affirmed by making the privy purse an expenditure charged under the Consolidated Fund of India, and the use of expression guaranteed or assured by the Government of Dominion of India to any ruler as embodied in Article 291, and the expression guarantee and assurance given under such covenants or agreements as is referred to in Clause 1 of Article 291, as comprised in Article 362, was a permanent feature of the Constitution, reflecting the intention of the founding fathers of the Constitution, and as such, these two articles should have been kept intact. Please pause here for a minute. My Lord, these articles even remotely did not suggest that they are temporary. As against, my Lord, 370, which by its very definition says and it's temporary, and I will also, my Lord, be able to attempt to demonstrate that it could never have been but for temporary. Such a drastic provision, the visionary fathers and mothers of the Constitution would never have kept it permanent, where two organs can change the Constitution the way they like. But that's a separate argument. Please see. According to the learned counsel, the deletion of these articles amounted to a gross breach of principles of political justice enshrined in the preamble by depriving or taking away from the princes the privy purses which were given to them as consideration for surrendering all their sovereign rights and contributing to the unity and integrity of the country. Patabi Sitaramaya were only remarkably confirmatory of the permanence and indefeasibility of the aforesaid guarantee and assurances, but also went a long way in determining that the said guarantees and assurances have come to stay as an integral and untouchable part of the basic structure of the Constitution. Finally, it was said that there can be no basic structure of a Constitution divorced from the historical evolution of precepts and principles on which the Constitution is founded. Any effort to determine the basic structure of the Constitution without keeping a finger on historical pulse of the Constitution may well lead to substantial injustice. According to him, if the historical approach to the test of basic structure is kept in view, the guarantees and assurances of the privy purses, privileges, etc., granted by the Constitution makers by incorporating Article 291, 362 and 366(22) in the Constitution framed by them would, without any doubt or dispute, emerge in their own right as basic features of the Constitution which cannot be abrogated or annihilated by any constitutional amendment, etc. Now, your Lordship, my Lord, kindly see para 28 at page 551. The learned Attorney General of India, with regard to the above pre-constitutional agreement, stated that history of the developments leading to the merger agreements and framing of the Constitution clearly show that it is really the union of people of native states with the people of erstwhile British India, and the instruments of accession were only the basic documents but not the individual agreements with the rulers, and therefore to attribute the agreements entered into by rulers as a sacrifice by the rulers is unfounded. Secondly, the nature of the covenants is not that of a contract, because a contract is enforceable at law, while these covenants were made non-justiciable by a constitution, vide Article 363. According to him, the covenants were political in nature, and that no legal ingredients as the basis can be read into these agreements, and that the guarantees and assurances embodied in Article 291 and 362 were guarantees for the payment of privy purses. He has urged that such a guarantee can always be revoked in public interest pursuant to fulfilling a policy objective or the directive principles of the Constitution. That being so, theory of sanctity of contract or unamendability of Article 291 or 362 did not have any foundation. He continues to state that the theory of political justice is also not tenable because political justice means the principle of political equality, such as adult suffrage, democratic form of government, etc. In this context, your lordships can skip, my lord, the citation. Then para 29. Before embarking upon a detailed discussion on the various facets of the contentions, both factual and legal, we shall deal with the precursive point with regard to the pre-constitutional instruments of accession, the merger agreements, and the covenants which guaranteed the payment of privy purses and recognition and personal privileges, etc., and which the agreements ultimately facilitated the integration of these states with dominion of India. Then, my lord, 30, your lordships may skip its history. 31. This accession of Indian states to the dominion of India established a new organic relationship between the states and the government, the significance of which was forging of a constitutional link or relationship between the states and dominion of India. The accession of Indian states to dominion of India was the first phase of the process of fitting them into constitutional structure of India. The second phase involved a process of twofold integration, the consolidation of states into sizable administrative units and their democratization. Though high walls of political isolation had been raised and buttressed to prevent the infiltration of the urge for freedom and democracy into Indian states, with the advent of independence, the popular urge in the states for attaining the same measure of freedom as was enjoyed by the people in the provinces gained momentum and unleashed strong movements for the transfer of power from rulers to the people. On account of various factors working against the machinery for self-sufficient and progressive democratic setup in the smaller states and serious threat of law and order in those states, there was an integration of states, though not in a uniform pattern in all cases. Firstly, it followed the merger of states in the provinces geographically contiguous to them. Secondly, there was a conversion of states into centrally administered areas. And thirdly, the integration of their territories to create a new viable units known as Union of States. My lord, your lordships may, my lord, now come to para 38, my lord, at page, my lord, 554, PDF 554. Now, my lord, the Honorable Court discusses Madhav Rao, because Madhav Rao obviously was cited. That which said that privy purses are an integral part of the Constitution of India. That is one. And number two, that you could not have taken it away by merely deleting the definition of princes. These were, my lord, the two. Then 38. On May 14, 1970, the Constitution 24th Amendment Bill for abolition of the aforesaid privy purse, privileges, etc., conferred under Article 291, 362, and 36622 was 366-22 was introduced in Lok Sabha by the then Finance Minister Sri Chavan. The bill contained 3 clauses and a short statement of objects and reasons. The statement reads as under: the concept of rulership with privy purses and special privileges unrelated to any current function and social purposes is incompatible with an egalitarian social order, government have therefore decided to terminate the privy purses and privileges of rulers of former Indian states. On September 2, the bill was voted upon in Lok Sabha, but on September 5, Rajya Sabha rejected the same since the bill failed in the Rajya Sabha to reach the requisite majority and not less than two-thirds present as required by Article 368 and voting. Close on the heels of the said rejection, the President of India, purporting to exercise his powers under Clause 22 of Article 366 of the Constitution, signed an order withdrawing recognition of all rulers of the country en masse. Look, this was the subject matter in Madhav. A communication to this effect was sent to all rulers in India who had been previously recognized as rulers. So what was done was, by a constitutional order, which is unheard of, my lord, except in 370, the Honorable President virtually declared two provisions to be nullity. The presidential order, para 40, de-recognizing the rulers were questioned in Madhav Rao, Scindia versus Union of India by filing writ petition under Article 32, challenging it as unconstitutional, ultra-virus and void. An 11-judge bench of this court, by its judgment dated so-and-so, struck down the presidential order being illegal, ultra-virus and inoperative on the ground that it had been made in violation of power of the President of India under Article 366(2) of the Constitution, and declared that writ petitions would be entitled to all their pre-existing rights and privileges, including right to privy purses, as if the impugned orders therein had not been passed. Here, it may be noted that Justice Mittal and Justice Ray gave their dissenting judgment. Thereupon, that they started getting privy purses. But kindly come to para 77 at page 562. Rest, my lord, may not help, my lord, assist your lordships, my lord, either way. 77. According to Mr. Swaraj,
Well, there you have it, viewers, the day-to-day hearing of the Article 370 in the Apex Court, where the SG Mehta, in fact, Solicitor General Tushar Mehta had been arguing and had stated that today in the arguments that will be presented before the bench, he will be covering three particular topics, which is that of the interpretation of Article 370, and which he, in fact, also says with a caveat that according to them, that the correct interpretation is that of the government as well, and the second is that of the State Reorganization Act, and the third is that of the parameters of the power of the legislature during 356 as well, is something that he had stated that he will be covering in today's argument that will be put forth before the bench. And in the series of arguments still up till now that the SG Mehta has put up before the bench, he has also cited several judgments, particularly that of the Madhav Rao Scindia judgment as well, and has stated that after the judgment of Madhav Rao Scindia, there was a constitutional amendment and the government repealed it, and this route was taken because of that, and hence today the challenge and the matter has to be put forth
Lord, this guaranteed them not only privy purses, some privileges.
Correct.
Lord, all states were divided into gun salute states. Somewhere 21 gun salute, somewhere the smallest was one gun salute.
They did refer to presidential orders in that merger agreements also. No. At that time, there won't be any president as such.
No, my lord, there was none.
No. Because at the time when the agreements were signed, there won't be a.
Thereafter, the constitution was made and the honorable president was elected.
The petitioner.
No, merger agreements were signed by Dominion of India or subsequently Government of India by the Secretary, Minister of State, Ministry of State. VP Menon, Lord, essentially is the signatory.
And 75 make a brief reference.
Yes,
Para 74 and 75, there is a brief reference to all these agreements.
correct. I'm okay. But your lordships are on para. Lord, may I read para 75, my lords? May I?
Yes, para 75.
70. Therefore, there cannot be, my lord, it is on page 561. Possibly that's what, my lord, the Honorable Court is reading. Therefore, there cannot be any justification in saying that guarantees and assurances given to the rulers were sacrosanct and that Article 291 and 362 reflected only the terms of the agreement and covenants. In fact, as soon as the Constitution came into force, the memoranda of agreements executed and ratified by the State of Union of States were embodied in formal agreements under the relevant articles of the Constitution, and no obligation flowed from those agreements and covenants, but only from the constitutional provisions. To say differently, after introduction of Article 291 and 362 in the Constitution, the agreement and covenants have no existence at all. Everything gets subsumed in the Constitution itself.
In fact, that is the proclamation which Karan Singh issued after the adoption of the Indian Constitution. That thereafter, the entire relationship will be governed by the Indian Constitution.
Yes.
And all previous covenants, agreements will cease to have any application.
They are, my lord, therefore, I said, my lord, it gets subsumed. And now the final document is the Constitution of India, which we have given to ourselves. To say differently, after the introduction of Article 291 and 362 in the Constitution, the agreements and covenants have no existence at all. The reference to covenants and agreements was casual and subsidiary, and the source of obligation flowed only from the Constitution. Therefore, the contention urged on the use of the words guaranteed or assured is without any force and absolutely untenable. The next vital issue is whether the Impugned Amendment Act damaged any basic structure or essential feature of the Constitution. According to Mr. Surabji, the repeal of Article 291 and 362, which were an integral part of the constitutional scheme, the identity of the Constitution has been changed and its character has been fundamentally altered. The total repeal of these articles, coupled with an express repudiation of the guarantees embodied therein, has resulted in nullification of a just quid pro quo, which were the essence of these guarantees. He has urged that the underlying purpose of doing justice to the rulers has been subverted and breach of faith has been sanctioned. He has relied upon these judgments, including, my lord, 3 is Madhav Rao Scindia. And please see, my lord, 79. Mr. D.D. Thakur, the father of my Lord Justice Thakur. My Lord, the Chief Justice Thakur. D.D. Thakur, in addition to the above, has stated that one of the tests to determine whether the provision of the Constitution was intended to be permanent or could be deleted or amended is to see whether the constitution makers had intended that to be made permanent. In support of this submission, he placed much reliance on the observations of Justice Mudholkar in Sajjan Singh. My lord, I can skip that. And thereafter, my lord, I may directly come to 88 at page 563. Your Lordship has, my Lord Justice Gavai and Justice Soria. Mr. Solis Sorabji, in support of his contention that Article 291 and Article 362 and Clause 22 of the Article 366 were integral part of the constitutional scheme, which otherwise would mean the essential part of the constitutional scheme referred to Webster's Dictionary and Collins' Concise Dictionary, and has pointed out the lexical meaning which says the integral means essential, and therefore, according to him, the total abolition of provisions of the Constitution, which are in its integral parts, otherwise essential parts, has damaged the essential and basic features of the Constitution. To draw strength for his submission, he relied upon certain observations made by Justice Shah in his judgment in Madhav Rao, observing, now, my Lord, Madhav Rao is dealt with, my Lord, and distinguished. By the provisions enacted in Article 366(22), 291 and 362 of the Constitution, the privileges of rulers are made an integral part of the constitutional